Hello all, welcome to the Lucid Means program by Ekam IAS. Today we are going to look at a question, why no Lokpal yet? To do this, we are going to look at some topics like why Lokpal is in news, what is Lokpal and Lokayukta Act, what are the major features of that act, what is the connection between Lokpal and CBI, why there is a delay in appointment, opinions from different institutions, what are the drawbacks, and how to resolve this issue. First, we are going to look at why Lokpal is in news right now. The term Lokpal has come into light right now is because of the burning issue between CBI Director and Special Director and the connection Lokpal has in that issue. Lokpal and Lokayukta Act 2013 has amended the Delhi Special Police Establishment Act 1946, which runs the CBI. This amendment has replaced the CVC-led panel with a high-powered committee, that is the Lokpal Selection Committee, under the Prime Minister in recommending the CBI Director. Act also says that a prior approval from this committee, that is the Lokpal Selection Committee, is required to remove the Director. But considering the special situation that has occurred, CVC recommended and the government thus removed the CBI Director as an interim measure. CBI Director approached the Supreme Court and the issue is right now under Supreme Court's scrutiny. So, we will look at what is Lokpal and Lokayukta. The Lokpal and Lokayukta Act 2013 has come into force on January 2014. The idea of an anti-corruption body and an ombudsman to look into corruption allegations against administrators, including legislatures, has been floating around for 50 years right now. It finally got shape only after a nationwide protest led by India Against Corruption, a civil society movement of activist Anna Hazare. Lokpal is an authority representing the public interest who will investigate corruption in the government at the national level. The 2013 Act gives it jurisdiction over all categories of public servants, including the Prime Minister. Lokayuktas are bodies that take care of the same at the state level. Now we will look at what are the major features of the Act. The section 3.1 of the Lokpal and Lokayukta Act says that there shall be a Lokpal at the national level on the commencement of the Act. It also says about Lokayuktas at the state level and it has to be constituted within 1 year of the commencement of the Act. The Act includes provisions for attachment and confiscation of the properties which are acquired by corrupt means even while the prosecution is pending. This Act protects all the public servants who act as whistleblowers. To do this, they have a special Whistleblowers Protection Act established. As per the Act, the Lokpal can summon or question any public servant if there exists a prima facie case against that person, even before the investigating agencies like Vigilance or CBI has begun the probe. Its inquiry wing has all the powers of a civil court. Lokpal will have the power of superintendence and direction over any investigating agency including CBI in cases referred to them by Lokpal. The Act provides provisions for setting up a special court to conduct trials if they feel that the case is of extreme importance. Also, Lokpal can award fines up to 2 lakh for false complaints. Now we will look at who appoints Lokpal. A 5-member panel called Lokpal Selection Committee comprising the Prime Minister, the Lok Sabha Speaker, the Leader of Opposition, the Chief Justice of India or a sitting Supreme Court judge as nominated by the Chief Justice and an eminent jurist nominated by the President of India selects the Lokpal. The jurist has to be nominated by the President on the basis of recommendations of the first 4 members of the selection committee. Then we will look at what is the structure of Lokpal. Lokpal is a team or a multi-member body. It can have a chairperson and maximum of 8 members. 50% of this should be judicial members. And also 50% of the members of the Lokpal shall be from scheduled caste, scheduled tribes, OBCs, minorities and women. Now we will look at what is the connection between Lokpal and CBI. As we above said, the Lokpal and Lokayukta Act has replaced the CVC-led panel with a high-powered committee chaired by the Prime Minister, which also includes the Chief Justice of India and the Leader of Opposition in recommending the selection of CBI Director. This amendment to the DSP Act 1946 was passed by the Parliament. Act also provides provisions to constitute a Directorate of Prosecution headed by a Director of Prosecution under the control of CBI Director. This will happen on the recommendations of the Central Vigilance Commission. Also, the transfer of officers of CBI investigating cases referred by Lokpal could happen only with the approval of Lokpal. Next, we will look at why there is a delay in appointing a Lokpal. 4 years have passed since the Lokpal and Lokayukta Act 2013 was passed by the Parliament, but not a single Lokpal has been appointed. The major challenges faced could be: first, the law requires the leader of opposition to be a member of the committee that will appoint the Lokpal. But there is a special situation now that there is no leader of opposition in present Lok Sabha. For the opposition parties to have a leader of opposition, they need to have a strength of at least 10% of the total seats in Lok Sabha, and as of now, there is no party in the opposition which have achieved this mark. Because of the current situation, the idea of having a leader of opposition on the panel has been changed, and the amendment has been called for the leader of the largest opposition party to be on the panel for selecting the Lokpal. This amendment was moved, the standing committee approved it, but yet it has to be tabled on Parliament. The second is, there was a demand in the selection committee that it has to give importance to the views of Chief Justice in selecting the jurors to the search committee. The third one is, there is no urgency visible either from the government's part or from that of the opposition, as this is an issue of political will. All these delay is despite the fact that the United Nations Convention Against Corruption way back in 2011, and Indian government is committed to end corruption and to take necessary action to complement that. Now we will look at what is government's stance in this issue. The government said that the Lokpal Selection Committee, comprising the Prime Minister Narendra Modi, the then Chief Justice of India Deepak Misra, the Lok Sabha Speaker Sumitra Mahajan, and eminent jurist Mukul Rohatgi, had met to frame a constitution for the search committee, which has been formed to search and recommend names to the post of chairperson and members of Lokpal. Based on these recommendations from the Lokpal Selection Committee, the government has constituted an 8-member search committee on September. This search committee will be headed by the former Supreme Court Judge Justice Ranjana Prakash Desai. The details of other 7 members are given in the material, and the link to download that is there in the description box below. Government has also said that since there is no leader of opposition in the present Lok Sabha, they could not include him in the Lokpal Selection Committee, and also that a bill to amend this provision and to include the opposition is pending in the Parliament. Government also commented that Supreme Court has no powers to direct the government on when and how the law to be enforced, as passing a bill is the sole responsibility of the legislature and the judiciary cannot interfere in that. They also said that the process of Lokpal selection is going as per the guidelines laid down in the Lokpal Act. Now we will look at what is Supreme Court's opinion in this issue. The Supreme Court said that the Lokpal and Lokayukta Act of 2013 is an eminently workable piece of legislation which is needed to be implemented without any further delay. To strengthen this command, the court held that Section 4.2 of the original Lokpal Act makes it clear that the available members of the Lokpal Selection Committee, that is without the leader of opposition, could appoint the Lokpal. Supreme Court also added that it cannot push the issue any further as it cannot overstep its jurisdiction and encroach into the power of legislature to pass a bill. Then what are the opposition's arguments? Opposition says that the government has ignored all the concerns raised by them and the people while constituting the selection committee. They fears that the Lokpal Selection Committee, in the absence of opposition, would appoint candidates who are favoured by the government and the ruling party to the Lokpal. It thereby defeats the very purpose of the law. So, to preserve the spirit of the law, the amendment on the leader of opposition status should be passed in both House of Parliament as soon as possible, and then a selection committee has to be constituted and a Lokpal to be appointed. They also complains that the similar amendment to the DSP Act for the appointment of CBI Director was introduced by the government and was passed very quickly. But in the case of Lokpal law, instead of bringing a single amendment to alter the composition of the selection committee, the government introduced a 10-page bill which proposed to fundamentally dilute the original law. Now we will look at what are the drawbacks of the Act. Lokpal and Lokayukta Act is a wonderful act if implemented in its pure form, but there are some problems which should be addressed. The first one is issue in asset disclosure provision. The original Lokpal Act requires a public servant to declare his assets and liabilities and that of his spouse and dependent children. Such declaration must be made to the competent authority within 30 days of entering office. Further, the public servant must file an annual return of the assets and liabilities that he has by July 31st of every year, and statements of such declaration to be published on the website of the relevant ministry by August 31st of that year. But the Lokpal and Lokayukta Amendment Act 2016 replaces these provisions. Even here, the public servant will be required to declare his assets and liabilities, but the form and manner of making such declarations will be prescribed by the central government, and the matter of spouse and children are not clearly discussed here. We know that Lokpal was established to act on Complaints Against Prevention of Corruption Act. Since illegally acquired assets are often handed over to the family members, public declaration of assets of the spouse and dependent children of the public servants was necessary to enable the people to make informed complaints to the Lokpal. The second is that issue on permission of prosecution. There are many examples which expose that requirement of seeking prior sanction from the government for prosecuting a government official is a critical bottleneck and results in huge delays and may help the culprit to escape. To address this problem, the Lokpal Act vests the power of granting sanction for prosecution in the independent institution of the Lokpal. But the recent amendments to the Prevention of Corruption Act strengthen the requirement of Lokpal to seek government's permission before prosecuting a public servant by increasing cover to even retired public officials. The third problem is that since provisions of Lokayukta are unclear in the Act and the states are given complete freedom to decide on appointment, composition and powers of Lokayukta, there are chances that Lokayukta may remain weak in some states. And the next is that Lokpal will supervise CBI only on cases referred to it by Lokpal. So the CBI will continue to face the issue of independence on other cases and issues. The next is that the Lokpal will look into corruption cases only after their occurrences, whereas a significant reduction in corruption requires a preventive systematic reforms. And the last one is that institutions like army, judiciary and Lokpal itself are kept out of the purview of Lokpal. That means Lokpal cannot conduct inquiry against itself and it's a problem. Now we will look at how to approach the issue. The need for a governing body which can hold the ever-increasing corruption in our nation has become the need of the hour for a developing country like ours. An anti-corruption committee has all the potential to take our country's governance to a next level. Lokpal is the key institution in the fight against corruption, and the delay in its implementation has created a strong perception that the government does not wish to put in place an effective anti-corruption institutional framework. The Lokpal law was demanded by the people of the country as there was a need for an independent and empowered body to look into the cases of corruption of public servants. The stated objective of the law is to provide for prompt and fair investigation and prosecution in cases of corruption. Also, an important principle for ensuring independence of the bodies like Lokpal is that the selection committee responsible for making appointments to these institutions should not have dominance by the members of the government and the ruling party. Thus, to uphold the spirit of the law, the government should take immediate steps to ensure that the leader of opposition is recognized or that the requisite amendment to change the composition of the selection committee would be urgently brought before the parliament for passage and should appoint a Lokpal as soon as possible. That's all and thanks for watching.